Welcome to part 2 of our post-conviction conversation with the Court of Criminal Appeals. You mentioned that the need to be persuasive. How can practitioners better frame issues for appellate review in post-conviction cases?
Right. From my perspective, it begins knowing what the standards are. So it's not just enough to come into court and say, hey, trial counsel just kind of messed it up. Trial counsel should have done X, Y, and Z. They didn't do it. It's about knowing what the standards are. If I know that I also have to show to get relief that whatever the deficiency was impacted the outcome of the trial, affected or would have affected the outcome of the trial, then I can begin to be persuasive in terms of showing the trial court, the post-conviction court, that I'm entitled to post-conviction relief. Then to be able to argue maybe persuasively in the appellate court that maybe the post-conviction court got it wrong in its factual findings as it goes. It begins with knowing what the standards are and then being able to marshal that proof at the hearing to be able to meet those. From my perspective, it seems like a lot of time, even on appeal, when we're listening to when we're hearing cases dealing with post-conviction cases, it seems like the lawyers do not understand sometimes what the standards are, what they have to show. Typically, we're arguing how trial counsel was terrible, but we're never arguing about how that would have impacted the outcome of the trial.
A good example, Nick, of what Judge Greenholtz was just talking about. We've been talking about post-conviction relief in the context of a criminal trial. You can also seek post-conviction relief if you've entered a guilty plea. Mm-hmm. And a lot of times the lawyers just think, well, I'll put my client, the petitioner, on the stand just to say, yeah, my lawyer never showed me the discovery. If I had seen this discovery, it would have made a difference. Well, you have to know the standard is, but for that deficiency in the attorney's performance, the outcome would have been different. In other words, he would not have pled guilty. He would have gone to trial. And so a lot of times they'll just argue that the lawyer should have done something without actually showing proof that the lawyer's error is what led to the guilty plea in the first place. And if you don't understand the legal standard, you're not going to know what to elicit from your client.
Judge Campbell, do you have anything to add?
I think that kind of sums up what I've seen as a trial judge, and even when I was a prosecutor, is this disconnect between wanting to criticize, I guess best, criticize this lawyer for he didn't do what I did. Okay, well, that doesn't necessarily mean that what he did was below the standard of what we expect of attorneys, or that what he did impacted to a negative effect the client's the outcome of the client's case. So basically, what I see a lot of times, at least when I was a trial judge, is just basically airing dirty laundry, but really not having anything at all to connect the dots to something that I can use if I was going to find prejudice. So, I mean, I agree. I think preparation is important, marshaling your proof, not going in and just throwing in a bunch of allegations that you're not going to really be able to prove, because I think that effect negates maybe something that has some merit. It gets buried in all the other garbage that's in there. I think some of the best petitions I've seen are the ones that are very focused on the one particular problem that you can kind of expand on, as opposed to getting it lost in 20 other issues that there's no way in the world you're going to be able to prove, and it just hurts your credibility.
So we've been talking about this from a trial court level. Although you were all former trial court judges, you are now Court of Criminal Appeal judges. What are some of the most common reasons post-conviction cases are reversed or remanded by the Court of Criminal Appeals, including issues with the trial court's findings?
Or the trial court's non-findings. I mean, that's become something that we've seen a lot lately, is where there's a requirement. It is required under the statute that the trial court prepares a finding of fact and conclusions of law. And we've had cases sent back because they didn't address all the issues that were raised by the petition. There were issues that just are hanging and they didn't address them, or where they just filed some order that doesn't establish the reasons or the findings of the court, just kind of a summary dismissal. Those are those kind of things we've seen and are entirely preventable if the court is doing what it's required to do under the statute.
No, I was going to say I've seen the same thing. I think from my perspective, maybe on the trial bench, Post-conviction orders are also something that are different from typically what I would be doing otherwise. A lot of times on the trial court bench, the trial court judge will rule from the bench. So let's say that I have a motion to suppress evidence, for example. Let's say maybe a confession that they claim was obtained in violation of Miranda versus Arizona. I may actually rule on that from the bench. I might not issue a written order on it. Sometimes I would, but I might not. In a post-conviction case, though, it's going to require a written order every time. That written order is going to have to require findings of fact, as Judge Sword said earlier, what actually happened. Who does the trial court believe? A lot of times what I've seen, look, I'm not perfect, so I'm not throwing shade on anyone, but a lot of times what I'll see in orders is that the post-conviction court will never make a credibility finding. And we're having to infer then, from the other findings that are made, who the post-conviction court found to be credible. If the post-conviction court made that finding on the front end, I think that would really help facilitate a lot of those factual findings. And then sometimes what I see also then is maybe just as sometimes some practitioners might not really know the standards coming into it. Sometimes maybe a trial court judge, and I was certainly this way, didn't have a whole lot of familiarity with post-conviction proceedings before I came onto the trial court bench. Requires a lot of education, trying to figure out what it is so that in crafting my order, I know what the standards are. I know what proof I'm looking for, or I know the effect of the absence of proof in some cases. And so I think what Judge Campbell is saying is exactly that. I mean, to craft a very good post-conviction order, you have to be attentive to what those findings are. As Judge Sword said earlier, you have to be attentive to where the credibility determinations are being made. And you have to be very attentive to the standards and what the law is. And then when all of those things come together, I think you're going to have a very good trial court order where we tend to send them back or where some of those are maybe missing.
And as Judge Greenholtz said, the statute actually requires that the judge reduce their findings to writing. And so we have really good trial judges in the state of Tennessee, and most of them have excellent instincts. And I think I was an average. I was a decent trial judge, and there were a lot of times when I would leave the bench thinking one thing, and I'd go back to write up the order. And after studying the law, I would realize my instincts weren't right on that issue. And the process of writing it out and thinking logically after determining what the standards are and thinking through the proof that I heard, what do I believe, it helps you as a judge to be able to understand what exactly am I supposed to be finding here, and then making those determinations. And so not only is it required by the statute, it's also really the only way to capture everything you're supposed to find as a judge, so the appellate courts can know exactly what you were thinking.
I will say this, maybe to follow up on both of those. I don't think there's this perception among our trial court judges. I don't know of anyone on the Court of Appeals who is starting off an appeal saying, well, you just got this wrong, I'm going to send it back. At least from my perspective, I'm not looking to send something back unless it has to be sent back because there's some kind of deficiency. If we can work with what the trial court's findings are, and we can do that in accordance with the law and the arguments, I think that's what we're going to do. I think when it goes back, at least in my experience, it's because there really is some kind of deficiency that's there. Like I said, I was brand new to all of this when I came onto the bench, largely from a civil practice, and so I understand how difficult it is to get up to speed, to get going, and to understand and put together some good orders. We've got some great judges, as Judge Sword says here.
It sounds like the written order from the judges need to be just as detailed. Judge Campbell?
Oh, absolutely. Because that's the way I look at it, is the order sets out the battlefield. I mean, that's where, when it comes up on appeal, what are the issues that we're going to have to address, or what the judge has identified and the facts he's found and the conclusions that he's made from those facts. That sets out our universe, because, if it's not addressed, then we usually don't see it. And the problem, going back to making a good order, is if the order conforms to the proof, that the judge's conclusions are supported by the proof, there's nothing we're going to be able to do to it, because he has basically, followed the standard that the statute sets out. He's established these facts. They're supported by what was the testimony by the evidence, and if he follows the law correctly, then there's really nothing we can do about that, and or should do anything about that. The problem runs into when the judge kind of glosses over certain issues or facts and leaves it ambiguous, and then it becomes harder for us to be able to say, well, the proof supports his conclusions, because he really didn't show concretely what he was relying on or where the record supports him. And so that's why it's so important for the court to really be specific about what it's finding and who it believes and how all that applies to the result in the case and if it had an effect or not.
This sounds like that most of these practitioners would be court-appointed practitioners, right? Once they get to the appellate level, I would say that most of the time they're indigent, or they're appointed counsel.
Almost all post-convictions are appointed, pretty much, and so many of them were public defenders in many ways beforehand. So the public defender's not on it. So you have a lot of times private practitioners who are then handling the appeal as appointed. The few that are PD, the PD has appointed counsel for appeal, but private counsel that's appointed, they're on their own.
So how should the practitioners decide whether a claim belongs in post-conviction proceedings, habeas corpus, a direct appeal, anything to correct an illegal sentence? How does that, in their mind, how do they go through that before they file the appeal?
For the purposes of appeal, then it's whatever was raised at trial as far as objection, what's raised. The motion for new trial is going to set out what the appeal is going to be about. Post-conviction then is beyond that. Then it's a whole separate, review of performance, basically, of the attorney. The trial attorney is not the person who handles the post-conviction, it's somebody else. And, that there's that focus. And we say post-conviction and ineffective assistance, but that's the most common area that you're going to see. Occasionally you'll have something come up where you'll have some allegation of jury tampering or something that came up that no one was aware of and couldn't have been raised on appeal. But for the most part, it's attacking attorney. When you get into other things like federal habeas corpus, that's even farther down the road, or habeas corpus in the state court, that's something completely separate and is a distinct creature of statute. So most practitioners, they're going to be dealing, if they're on the trial, then they're talking about direct appeal. After direct appeal, then you go into post-conviction, and usually that's a pro se filing that the court will then appoint counsel on. Occasionally you'll have somebody hired, but most of the time it's the defendant or the petitioner's filing from prison, and you're getting a pro se, and you have to decide, and this is another area that judges need to be careful about, is you get a post-conviction pro se. Is it timely filed? Does it raise enough allegations to be a colorable claim for you to then proceed with having an attorney on the case to amend it? Was it properly amended down the road? Because all this has to be accomplished before the court really has jurisdiction to hear the proof. And so it can get pretty complicated. And I think the biggest fallacy about all this stuff, and I agree with Judge Greenholtz, I think people don't take it seriously. I think they look at, it's a post-conviction, there's a lot of nuance, and people can get in trouble if they don't really understand how the statute works and what their obligations are to make sure it's timely filed and make sure it's adequately filed.
Judge Campbell brought up a good point that there are like a ton of categories and a ton of ways to do this. Are there particular categories of claims that are frequently misfiled in post-conviction petitions?
But there are a number of claims, and I think even before we came on today, Steve was saying, we're talking about post-conviction. In essence, everything after the conviction is going to be a post-conviction petition. Going back to your question about what maybe a practitioner should do, what kind of claim they should file, it's really not any different, frankly, from a client coming into your office saying, hey, I've got these set of facts. What relief do I have? What in the civil context, what kind of cause of action do I have? What kind of claim of relief might I have? And so if the client's coming in and there's a question about the fundamental jurisdiction of the court, I can think of lots of different ways that a trial court might not have jurisdiction, maybe from the indictment or an exclusive federal enclave or something like that, where the state court may not have jurisdiction. That tends to sound in state habeas cases. So as Judge Campbell was talking about, we have our Constitution guarantees the writ of habeas corpus. And what that is just an allegation that, hey, the trial court lacked jurisdiction in the case. My conviction is not supported by a court that had the power or the authority to act. Very limited. It's only limited to that very specific relief. But hey, a client walks into my office and says, hey, I've got this issue, then I'm thinking about habeas corpus. If a client comes into my office and says, hey, I have just discovered there is this new piece of evidence out there that fundamentally may have changed the outcome of my trial, I may be thinking now of a separate post-conviction remedy, which is called a writ of error coram nobis. Most of us have never heard of the writ of error coram nobis, particularly if we're not in the criminal law field. But it has its own procedures. It has its own standards that govern it, separate and apart from the Post-Conviction Procedures Act. On the other hand, if my client's coming into my office and says, hey, I really think my attorney goofed at my trial, and I think that had he or she done these other things, I think that the outcome would have been different. Now I'm thinking back in the Post-Conviction Procedures Act as it goes. There's a variety of actual kind of post-conviction remedies, and what it requires, though, in all of these cases is just like in the civil context, for a lawyer to be reasonably familiar with what the law is, reasonably familiar with what the law would require by way of relief, and then just be able to listen to the client, understand what is being said, and then to offer what kind of remedies might be available under kind of these different statutes and different procedures.
Now, I have a rule here on this podcast. If you're going to speak Latin, you've got to explain it. So writ of error coram nobis.
Yes, Sword would be much better than I would be on that stuff, certainly.
Yeah. All right, go for it, Judge Sword.
I'm not going to get into error coram nobis, but what I would say, there's a unique aspect to petitions for post-conviction relief that's unlike any other type of post-conviction remedy you might be seeking. Like Judge Campbell said, it's usually a pro se defendant filing something requesting post-conviction relief because his attorney fell below the reasonable standard. When the trial judge gets that petition, they have an obligation to determine whether or not it raises valid issues that can be countenanced under that statute. And if not, or if it's filed too late beyond the 1-year statute of limitations, the law says the judge shall dismiss that petition. And so there are times when a defendant may label it like a petition for post-conviction relief, but then they're really saying that I've exhausted my sentence. I've already completed the sentence. I shouldn't be held any longer. And the trial judge can say, okay, I'm going to treat this based upon the remedy he's looking at. Even though he calls it a petition for post-conviction relief, this is really a petition for writ of habeas corpus, so I'm going to treat it that way. But so a lot of these petitions, if they are not proper petition for post-conviction relief, they'll get dismissed before a lawyer ever even sees it.
So, when you're watching a football game and you see a coach run up like with 1 second left and call a timeout, is there any reason to file a petition for post-conviction relief at the end of the 1 year, or is the 1 year given just as a general rule?
Well, the statute says 1 year from the action of the highest state court, or, if it's a guilty plea after, 30 days after the guilty plea is taken, then it's final, then you have a year from that. But the statute's really clear. It's a year. You have 1 year to file. It is not a year from when the U.S. Supreme Court denies cert. It's from the highest state court. And some people fall into that trap, and they then file it 6 months late because they're waiting for the Supreme Court to rule on a cert petition. But no, but and I always am amazed. People wait to the last day to file. And to me, if there's an error, if you make a mistake, you have no way to correct it. So if you file it in error, you can wind up, not being able to correct it, and then it's going to be dismissed, and you're not going to be able to go refile it. So, but the law says it has to be filed within a year, and that's a hard year, unless you can come up with some really extraordinary circumstance that gets you a due process tolling, but it's the statute pretty much says it's got to be filed in a year and there's no exceptions.
Well, my question was more pointed at I could see some lawyer throwing it in at the last second for some strategic reason.
There's really not, frankly.
Okay.
And so, I mean, there really is not a strategic reason for waiting that long. Think about it like in a civil case. I keep going back to maybe civil cases as they go. A lot of times you'll have statutes of limitations in civil cases that are a year. So if you think maybe a personal injury case, for example, I got hurt in a car accident, I've generally got a year to file a complaint or a claim for relief there. No strategic reason to wait the year if you don't have to, but the reason that you have the year is so that proper investigation can be done on the front end to support the claim. And so what I would expect to see is that if a reasonably diligent post-conviction petitioner is waiting the year, I would hope that the petitioner is using that time to investigate the claims, to marshal the proof, such that by the time that the petition is filed, is that you've got a reasonably good support for the allegations that are being made. If you're not using the year to investigate, though, I can't foresee any strategic reason why you would wait. I mean, as Judge Campbell says, I mean, if I've got an issue now, I'm going to go ahead and seek relief now, right? Why would I want to wait in custody for another year just to do it? That year is given, I think, for the ability for some meaningful investigation to occur. And if that's not occurring, I can't imagine why you would go and try to get a timeout from the refs. Yeah.
Judge Ford.
One of the things that you really need to keep in mind when you're talking about this whole act that the legislature passed is the short time frame that you have to deal with these. And the legislature intended for this not to drag these cases out. And you can see that it used to be 3 years. You had a 3-year statute of limitation.
You used to have no statute of limitations.
Yeah, that's right.
Well, I mean, before that. And so the legislature, they want finality to these cases. And so you say your pro se petitioner waits till that last year to file it. The trial court has to look at that petition within 30 days and then determine if an attorney should be appointed or if it should be dismissed. And then 30 days from there, the attorney, if they get appointed, they have to amend it. And then they can ask for an extension for good cause. So that's the only place you might have a little bit of delay is the lawyer having to do some more investigation to amend it. But after that, once the amendment's done, then the state has 30 days to answer. The court has 30 days to determine if a hearing is needed, and then they have to set that hearing, preferably within 60 days. They got 4 months, and they can maybe extend that up to another 60 days, and then they have 60 days to rule. So if you look at the timeline, every one of these petition of post-conviction relief should be done within 10 months of when that judgment or when the petition was filed before the trial court. And you'll see these things lasting for years, but that's because nobody's really following the statutes. But it really, timeliness is essential in the Post-Conviction Relief Act.
Have any of you observed any recent trends in Tennessee post-conviction litigation that practitioners should be aware of?
The one thing that I don't know, I don't see this being anything the legislature would probably do, but the one, I guess, problem, if you want to call it a problem, I'm just going to say problem because it's the easiest thing to say. If you are indigent and you are alleging that an expert should have been called, the trial court cannot appoint an expert to help you unless it's a capital case. So unless you have a way to fund your own expert, the court cannot appoint you one. So that is something that I don't know whether it's ever going to be addressed. I'm sure nobody wants to spend that kind of money because it can get really expensive. But that's one thing that, lawyers find out, they take an appointment and think, oh, I'm going to get the court, it's an indigent case. Statute doesn't allow for it unless it's a capital case.
Yeah, that's the one I was considering. I had a case before I left the trial bench where pro se defendant did not want appointed counsel. He was representing himself on the post-conviction petition, and he had been speaking with an expert witness in Memphis. I was in Knoxville, and he was wanting to bring this guy from Memphis and is asking me how to get funding for it. Told him, I can't help you there. If this was a trial, then I can point you to the rule that allows you to submit an application to the AOC to get funding for it. There's no provision for that in post-conviction relief. And so I can see why that particular defendant was upset with me, but that's the current state of the law.
Judge Greenholtz.
Yeah, it's interesting about maybe trends in post-conviction. So as you know, Nick, I mean the Court of Criminal Appeals came about in 1967 in conjunction with the Post-Conviction Procedures Act. So before that time, all criminal cases went to the Tennessee Supreme Court by way of direct appeal. The federal courts were heavily involved in reviewing state convictions under the federal writ of habeas corpus and maybe some other procedures too. And the State Post-Conviction Procedures Act came about as a way for the state to review our own convictions and maybe get some deference on things that were being done from federal review. I mean, that's the whole purpose of the State Post-Conviction Procedures Act. But let me emphasize that. I mean, this goes back to 1967. So although it has been amended in some cases over the years, it has largely remained the same in terms of its basic structural procedures as it goes. And so I think as I'm looking forward, what are some issues that we're going to be confronting? I do foresee maybe some impact with AI. One of the ways you get back into court is to claim that, hey, I've discovered new evidence. Not only is that, to use the Latin phrase again, not only is that under possibly a writ of error coram nobis, in some cases it also could be post-conviction relief also. It could state a claim for post-conviction relief. We may be confronting those types of issues where we're having to decide, is this really new evidence or is this AI generated? And then how do we go about addressing those kinds of claims? At least in terms of the fundamental procedures, though, that govern it, I think this is pretty well established. The case law is voluminous. It takes a while to get through as it goes. But I think, once again, that just emphasizes the need for practitioners in this area, both for petitioners, also on behalf of the state, just to be aware of what is being required there. But it'll be an exciting time. We're moving into with artificial intelligence. We're moving into an exciting time with the judiciary. It'll be I'll be curious to see how that impacts post-conviction proceedings.
I'm going to ask all three of you this: if you could offer one piece of advice to defense attorneys handling these narrow post-conviction cases, and one to the trial judges overseeing them, what would they be to each?
Take it seriously. I mean, I think that the practitioner needs to look at it as more than just, hey, I'm going to get this appointment, I'm going to get $1,000, and I'm going to put my client on the stand, and he's going to tell the court what happened, and then that's. And I think the court needs to take it seriously. This is just another afternoon I got to give up for whatever. It's important that they understand their role and understand the need to establish facts and make adequate findings, understand what the role of each of these different parties is. I mean, I just think some people just don't take it that seriously.
And playing off of what Judge Campbell just said, I remember as a trial judge, I would have, post-conviction hearing that I needed to docket. And, I've got several homicide cases that I'm trying to get done. I've got motion to suppress. And sometimes you can look at these and think, oh, this is just a waste of time. But you have to remember that the legislature determined that if they can raise a proper claim, the defendant has a right to have these issues heard. And so you need to put, as a trial judge, you need to put as much effort and energy into that post-conviction proceeding as you did in the original trial or the original guilty plea.
Because if you don't, you're going to be seeing it again. And that's the thing. I don't want to do things twice. I just see too many. If you leave too much open, bad things can happen. If you don't cross your T's and dot your I's, you can wind up having to deal with it again for a stupid reason.
I think from my perspective, the advice I would give is the advice I maybe typically give. And that is, if I'm practicing in this area, let's say I'm representing a post-conviction petitioner. Let's say I'm an assistant DA and I'm representing the state and I'm trying to make sure that the conviction that I worked so hard at trial to get, that finality is preserved. The one piece of advice I would have is be extraordinary. Understand what you're getting into. Don't be afraid, particularly with the lawyers representing the petitioner, don't be afraid to get out and interview witnesses. Don't be afraid to call witnesses. Don't be afraid to offer the proof. Don't just put it up there and let the trial court decide it. Give the trial court a basis to rule in your favor. Be bold about it. Know the standards. Do what all of us, when we were going to law school, we said we want to make a difference. We want to get out there. We want to help people. This is the opportunity to do it. And so many times you see this reflected in some of the experiences of my colleagues, and certainly mine too. Sometimes these proceedings, not always, sometimes these proceedings are treated lightly. They're not treated with the gravity that they could be, either because we don't think maybe the petition has merit, or we're having trouble with the client. Who knows? Maybe a whole lot of different reasons. Don't hesitate to be extraordinary. And even if you lose, there is value in doing a good job. And so that's what I think that would be the advice I would offer practitioners.
Well, I want to thank all three of you for joining me today on Tennessee Court Talk. I think it was a great discussion, learned a lot, and I hope our viewers learned a lot as well.
All Tennessee Court Talk episodes can be found at tncourts.gov.